Stating today that the defendant will waive her right to indictment, will plead guilty to the one count in the information. We will ask to defer sentencing so that a pre-sentence report, psychological evaluation, and victim impact statement may be ordered and completed. There's no sentencing agreement, and that is the state's understanding at this time.
All right,
Thank you.
Mr. Matthews.
That is all accurate, Your Honor.
All right, Ms. Rude, how old are you?
32.
And how far did you go through school?
I graduated high school.
Are you a United States citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
A couple of things. Intermediate explosive disorder, CPTSD, psychosis, and ADD.
Are you being treated for any of those conditions?
Just for right now, ADD. Possibly I should be starting or beginning to take psych medication for PTSD symptoms.
Have you taken any medication?
Not here, no.
All right. Did you get a copy of the information that was filed in this case?
Yes.
Do you understand that you have the right to have that case presented to the grand jury for them to decide whether or not to indict you?
Yes.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
Thank you, Your Honor. Prior to the hearing, I did review the waiver of indictment with Ms. Rude. She indicated that she understood it and that she intended to sign it. Sign on that line.
Here I have received the waiver of indictment. I witness the defendant sign the document and go to the court. Her counsel signed it, and I have signed it.
Okay, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk to Mr. Matthews some more, let me know and we'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right? Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control.
Yes.
Domestic violence is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Your Honor, it's a $5,000.
I'm sorry.
maximum fine.
$5,000 maximum fine. Do you understand that? Are you presently on post-release control to the parole authority?
No.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control for up to 2 years under the parole authority after your release?
Yes.
If you are placed on post-release control and you violate any conditions, a parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
Do you understand that if your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation?
Yes.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand, at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Matthews before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Absolutely.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 31st of 2024, shortly before 8 p.m., Willowick Police Department officers were dispatched to Bay Ridge condos, which are located on North Marginal Drive in Willowick, Lake County, Ohio. They responded regarding a disturbance involving Ashley Rude, the defendant, and Willis Joyner, at that time was her live-in boyfriend. When officers arrived, they were unable to get in through the door. They had to force entry. When they entered, the officers saw the defendant striking Mr. Joyner on his body. They found a bump on his head. All of this occurring in Lake County, Ohio. Through further investigation, officers learned that the defendant, Ms. Rude, had a prior domestic violence conviction in Cuyahoga County Court of Common Pleas, case number CR 11-551591, dated September 1st of 2011. And that would have been the state's evidence. Thank you.
Mr. Matthews, anything to add to those facts?
No, Your Honor.
Ms. Rude, did you hear what Ms. Cutts said the facts would show if the case went to a trial?
Yes.
And are those facts true?
Unfortunately, yes.
All right, what is your plea to domestic violence a felony for?
Guilty.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Ms. Rude. She indicated that she understood it and that she intended to cite it. No further questions, John? Okay. Put the date there, 3/24.
Your Honor, I've received the written plea of guilty and judgment entry. I witnessed the defendant sign the document. The oath of court, her counsel signed it, and I signed it.
Ms. Root, is this your signature on the written plea of guilty?
Pardon?
Is this your signature on the written plea of guilty?
Yes.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present.
Thank you.
Mr. Matthews advised of all of her rights, made a knowing, intelligent, and voluntary waiver of those rights. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept her plea of guilty and find her guilty of domestic violence, a felony 4. We'll refer this for a pre-sentence report, a psychological evaluation, and victim impact statement. Sentencing will be May 7 at 10 a.m. Mr. Matthews?
Thank you, Your Honor. Ms. Rood would like to address the court as to her bond. This case was bound over as a kidnapping as well as the domestic violence. The kidnapping was a felony of the 2nd degree, and the municipal court set bond at $100,000 with a condition of GPS monitoring. Ms. Rood has obviously been unable to post the bond at that level. She is requesting a bond of $5,000, 10%, with no GPS monitoring. We don't feel that that would be necessary. There has been no further contact between Ms. Rood and the victim in this case, nor does she intend for there to be. Ms. Rood does have a number of personal issues that she must address, specifically with her child. I will defer to Ms. Rood at this point to further explain those issues to the court, Your Honor. Thank you.
Go ahead, Ms. Rood.
Hi. I have a 7-year-old daughter, and since I've been here incarcerated, Child Protective Services and Child Support have contacted me. I have a letter to present. My parents, they have custody of my daughter, or they have my daughter right now. I have full custody of my daughter, and they're watching my daughter, and my parents are in their 80s. My mom has Alzheimer's, and my dad has to take care of my mom. I'm adopted into a really good family, and I feel kind of bad that my parents have to watch my daughter. I am worried that my daughter will be presented or in contact with her biological father. And I grew up in a really good area. I grew up in Gates Mills, and my daughter's never had to been subjected to like gunshots or, stabbings or anything gang affiliated. So if she is released to her biological father, I worry that my daughter will be caught in the crossfire of some serious street violence. So I was just wondering if I could be granted a bond so I can get back to taking care of my kid. Also, I require a CPAP machine. I have sleep apnea while I've been in here. And I'm trying to get back on psych medications. I do have a therapist outside of here, and I'm trying to get back into becoming a little more stable. So I was wondering if possibly I could be granted that. Also, I do apologize about this. You'll never see me in your courtroom again. This is a lot. It's very traumatizing, honestly, and it's hard being away from my kid. I talk to her every day since I've been in here, and I missed her birthday. She turned 7, and I've never missed a birthday before. Although the discovery packet, it looks like I'm a monster. I'm not a monster to my kid. I'm a phenomenal mother to my kid, and it's really rough being away from her. So I was wondering if I could just go home.
All right, Ms. Cutts.
Thank you, Your Honor. It is accurate that this case was bound over as a kidnapping and a domestic violence. Though the state understands the request for the reduced bond, there are some aspects that are concerning to the state. In this incident, the police were called because Mr. Joyner indicated he was not allowed to leave the apartment, that he was being blocked, and that the defendant had knives. When the police got to the location, they asked first Ms. Rue to open the door. She indicated she could not. Then they asked Mr. Joyner. He indicated he could not, that she was standing in front of it. They could hear that their voices were close to the door. nobody would open the door, and Ms. Rude indicated that she was unable to. When they said they were going to kick open the door, she told them not to. Before they did that, they heard commotion moving away from the door, and they believed an assault was in progress, so they did kick open the door, and that's when one of the officers saw the defendant striking Mr. Joyner multiple times inside the residence. There were some knives in the kitchen area with other dishes. When the officers got there, they had Mr. Joyner leave the unit, and they dealt with the defendant. Her then 6-year-old daughter was in the apartment through all of this, as well as the defendant, when she was told she was being placed under arrest and was handcuffed, sat to the ground and would not cooperate, would not get up, would not allow the officers to remove her. She screamed for extended periods of time at the officers, yelling and screaming. Her daughter was there the entire time. She would have her come over and hug her at times and then yell at the officers and scream. This was in Willowick. They only had a few officers on for New Year's Eve. They had to call in Wickliffe and Eastlake officers to come to the location to help physically carry her out of the unit. When they got to the stairs, she did agree to walk. As she was walking, she kept telling them not to touch her and was very verbally abusive. When she was placed into the cruiser, she proceeded to kick the divider between the officer and where she was in the back seat. Short of what happened in the cruiser, everything was in front of her daughter, who at times was in tears. One of the officers, who is sometimes at her school, was talking with her and taking her into the bedroom to try and keep her calm. It was an extended period of time that all of this continued on for, with the screaming and the yelling, to the point that Willowick did not bring Miss Rude into Willowick Police Department, where they normally do their initial booking before taking her to the Lake County Jail. They took her directly to the jail in concerns of her behavior and how she would act. Thankfully, when she arrived at the jail, she was cooperative with the Lake County Jail staff. But this was a very extended incident that could have been dealt with much more easily. The state is concerned for how she was behaving in front of her daughter, for how she was behaving with the officers, and feel that a higher bond is appropriate, higher than the $5,000. We do think GPS, as well as no contact, would be appropriate. In the past, the officers have indicated that Ms. Rude often will not open the door when they are called to the location, as well as she informed them that she was pregnant, so they cuffed her in the front. She was found not to be pregnant. They said that is also a common aspect. So at this point, we do feel at least a mid-range, if not higher bond, is appropriate even without the kidnapping charge, based on all the scenario that has happened, and in hopes of getting the pre-sentence report and psychological done in a timely, easy manner. Defendant does have prior convictions that include, obviously, the domestic violence in 2011. She also has an attempted aggravated assault in 2012 in F3. I believe there was also a misdemeanor assault in that case, and then some disorderly conduct. While she was initially released following the December 31st issue, and then there were a lot of calls back to the apartment with disorderly conduct and issues between her and Mr. Joyner, with both of them getting arrested at different times. So based on all that, we do feel that a $5,000 10% bond would be too low for this situation. Thank you.
All right, I'll reset the bond at $25,000 cash or surety or 10%, no contact with Joyner. Mr. Matthews, Ms. Rude presented a lot of information that I'm just not going to go on her word. If you want some further consideration, then you can file a motion, okay?
Can I say something? Sir,
No.
you didn't present that I had been the victim of sexual assault, and that's why I wasn't able to contact the police.
Well, that's not really a bond issue.
But that's still what the prosecutor said is not accurate.
What she said was accurate. It wasn't inaccurate.
That was not accurate at all. Because So what's my bond?
$25.
So
Should be
$2,500.
when will it be in the system so I can have it posted?
Yeah, absolutely.
I think early afternoon, 1, 2 o'clock.
What's the name? The prosecutor.
Alexander Cuts.
Alexander Dutt.
Do you want to see the blanket there in that chair?
Ma'am, thank you for letting me have this blanket.
Oh, you're welcome. Help and help.
Here.
And then when it comes to the arguments, are you able to say that, this is not just some type of domestic violence dispute or whatever,
Well, we're going to be able to present
like
whatever
happened
we...
in the past, and then I'm not just some weirdo that's gonna just claim to be pregnant. Do you need me to provide you documentation of these things? Because I don't like how she just presented that, that's ridiculous.
Well, I think
You can walk and talk to
we'll talk.
Which part did I leave out?
None.
Just check.
Not, she's a character. See y'all. See ya.
Definitely needs some mental health, I'll give her that. She's probably like night and day. I had a Mutter on the Lake police officer driving in the fast lane on my way to work, and he jimmied up out of traffic.